Kung yan ay pwede magamit sa challenge for admissibility, kung mayroong abuse of process, tsaka yung kung patas ba ang pagtatanggap ng ebidensya nito. Okay? Now, wait, tignan natin yung official statement. Ito ha. Tignan natin ha. Kasi gusto kong basahin yung official statement nila eh. Hindi ko lang mahanap ngayon. Kanina nahanap ko na eh. Ayan, ito. Ito, basahin ko na ha. Ito yung official nila. The ICC's Office of the Prosecutor has categorically denied all allegations that its investigators received money, bribes, or financial assistance from private individuals, political figures, or external parties in connection with the investigation of President Duterte's war on drugs. So, pinabubulaan nila, pinasisinungalingan nila na yung mga investigador daw nila ay tumanggap ng suhol at kahit anong pera galing kay Zaldico, kay Martin Romualdez at kay Trillanes. Sinabi nila na ang kanilang mga investigasyon daw ay pinondohan sa pamamagitan ng budget mismo ng ICC as approved by the Assembly of State Parties. Now, yung mga kanilang mga investigador daw at saka yung mga gastos ng mga investigador ay independiente, transparent at saka ayon sa patakaran ng ICC. Tapos, kinukolekta raw ng ICC ang lahat ng impormasyon yan ay ini-evaluate independently and evaluates incriminating and exonerating evidence equally. Hindi ko po alam ano yung exonerating evidence. Ang ibig sabihin po ng exonerating evidence, yung mga ebidensya na magpapatunay na wala namang kasalanan si Tatay Digong. No? Tinitignan daw lahat yan. Tapos, yung disclosure of information and evidence in cases before the court is strictly regulated by ICC legal framework and judicial oversight. Yung pag-release ng impormasyon na galing sa kanila, yan daw po ay sakop ng isang framework na sang-ayon po sa ICC. At hindi na po sila nagkomento sa mga paano ang mga gawain ginawa ng kanilang mga investigador, no? Dahil nga po sa confidentiality. Now, ang problema naman ito is bagamat sinasabi nila na independyente ang kanilang mga investigasyon, nagkaroon po ng paratang. Ano mga paratang? Well, ang paratang tumanggap kung hindi man ang pera, ng serbisyo at mga bagay-bagay ang investigador galing kay Sani Trillanes na ang pera naman ay nanggaling kay Zaldico. So kinakailangan, imbestigahan nila yan. Kasi syempre, makakaapekto kung saan nanggaling yung pera para sa kanilang tirahan, sa sasakyan, shopping money, doon sa pagiging objective ng kanilang pagkakalap ng ebidensya. For instance, bakit umabot pa sa puntong ito? Yung mga paratang na ang war on drugs daw ay systematic na patay ng sibilyan. Wala ba man lang nagbigay doon sa mga investigador ng desisyon ng Korte Suprema kung saan binasura ng Korte Suprema yung reklamo ng mga abogado ng mga biktima ngayon sa ICC na labag daw sa saligang batas at karapatan-ng tao ang tukhang. Now, sinasabi nila na ang Office of the Prosecutor daw ay patas at impartial sa kanilang investigation. Paano nila masasabi yan? Na-inhibit na nga, na-disqualify na nga si Karim Khan bilang isang prosecutor sa kasong ito dahil lumalabas na maaga pa lang, siya ay tumayo na bilang abogado ng mga biktima. So paano niya sasabihin na bilang isang prosecutor, siya ay naging independyente sa pag-i-evaluate ng mga ebidensya for or against Tatay Digong? Siyempre, naging bias na siya. Na si Tatay Digong ay may pagkakasala at dapat maparusahan. Samantalang sa sistema kasi ng ICC, dahil ito nga po ay tinatawag natin inquisitorial, yung fiscal na, yung prosecutor na talagang mag-iimbestiga at siya na magdi-decide kung merong paglabag sa batas o hindi. So kinakailangan tingnan niya yung ebidensya laban sa akusado at yung ebidensya na pabor sa abogado, sa akusado, at kaya nga po na-disqualify itong si Karim Khan dahil nga itinago niya yung pagiging abogado ng mga biktima bago pa man siya maging prosecutor sa ICC. Siyempre, bilang isang prosecutor, dahil siya minsan naging abogado ng mga biktima, pipikit niya mga mata dun sa mga ebidensya na magpapakita na walang pagkakasala si Tatay Digong. Gaya ng mga speeches ni Tatay Digong na sinasabi nga na binabalaan niya mga pulis na dapat tama ang gawain nila, otherwise hindi sila susuportahan ni Tatay Digong. Now, sabi pa ng ICC dito sa paratang ng mga marino The identity of sources, witnesses, and process of evidence collection are governed. Yung pagkuha daw ng mga ebidensya at saka yung paano tratuhin ng mga testigo at saka yung pagkuha ng ebidensya ay yan po daw ay sakop ng mga rules and regulations ng hukuman. At hindi na raw sila po pwedeng dokumento. Pero kinakailangan addressin nila tumanggap ba o hindi itong mga taong mga investigador na nakunan pa ng picture ng mga marino habang sila'y naririto. Di ba? So yan ang dapat nating malaman. So, well, sa akin hindi sapat yung sagot ng ICC. It begs more questions kasi parang yung sagot nila ay parang inaamin nila na totoo tumanggap sila ng impormasyon kay Triling, kay Zaldico, kay Reboying Remulla, pero ang tanong, tumanggap ba sila ng impormasyon or ebidensya dito naman sa mga taong nagsasabing walang pagkakasala? Si Tatay Digong, certainly ako, pwede nila ako imbestigahan o pwede nila ako pinatawag. Wala namang patawag sa akin. No? Samantalang, alam nyo, yung investigasyon ng ICC, alam na namin ni BP Sara yan. In fact, nasa amin na yung kopya ng mga passports nila habang sila labas-pasok sa Pilipinas. Hindi lang kami umaalma. Alam pa namin, ako pa nagsiwalat na nagpunta pa ng Kongreso para sa World Committee yung mga investigador na yan. At parang ang doon sa pagpupulong nila kasama si Abante, napagkasunduan na mag-public hearing na mapaamin si Tatay Digong na siya talaga nag-utos sa mga patayan na yan. Mantakin nyo, yung ba tamang investigasyon na nakikipagsabwatan doon sa mga kalaban ng nasasakdal para magkaroon ng ebidensya na magagamit laban sa akusado? Kung talagang walang pinanigan ng ang prosecutor, papayag ba sila na pupunta pa sila sa Kamara del Representante, kakausapin pa nila yung komite na mag-iimbestiga labang kay Tatay Digong at sila pa nagbigay kung anong kinakailangan nila na manggaling sa sariling bibig ni Tatay Digong? Mabuti na lang, kahit anong sabihin ni Tatay Digong, whether not under oath, kinakailangan, patunayan pa rin nila na yung patayan na nangyari ay bunga nga ng pananalita ni Tatay Digong. At kapag hindi naman nila napatunayan yun, wala pa rin mahihita ang prosecution. Okay, so sa kabila po ngayon ng mga discussion na lumalabas na hindi napatunayan ng prosecution, yung pinaka-importanting elemento ng crimes against humanity na ginurgura mga biktima dahil sila ay mga inosenteng sibilyan at alam ng Tatay Digong di umano na pinanggalingan ng organ ng gurgura na sila ay sibilyan, talagang wala po akong nakikita na kahit anong ebidensyang nagsasabi o ebidensya para magpatuloy ang trial. Bukod pa po dyan, dahil bagamat ang ebidensya lang nila ay pananalita ni Tatay Digong, dahil wala pang kahit anong ebidensya na nagpapatunay na kahit isang pagpatay ay dahil doon sa sinabi ni Tatay Digong, wala pa rin po talagang kahit anong ebidensya para magpatuloy ang trial. Alam nyo, kilala nyo ako na suporta ni Tatay Digong bilang dating tagapagsalita. Pero pag ako ay ganitong nagbibigay ng legal opinion bilang kauna-unahang asyano na natanggap as least counsel ng ICC at kapag ako ay nagsasabi ng kasinungalingan dahil ako ay nagsasabi lamang ng mga bagay-bagay na pabor sa aking dating amo, mawawalan ako ng kredibilidad. Pero ako po, tinataya ko na yung kredibilidad ko at yung sa mga sinasabi ko mga evaluation. Ako po ay patas sa evaluation. Alam niyo naman po, hindi ako fan ni Kaufman. Pero pag sinabi ko na tama ang sinasabi ni Kaufman, hindi yan dahil siya ay si Kaufman. Dahil ang sinasabi ni Kaufman ay sang-ayon sa nakasaad ng Rome Statute at sang-ayon sa nakaraan sa rules of evidence na ginagamit sa buong daigdig. Sa totoo lang po, dahil ako nga ay mayroong hindi mabuting relasyon kay Kaufman, dapat ino-okray ko si Kaufman every step of the way. Hindi ko po ginagawa yan dahil sinasabi ko naman, ang sinasabi ang mga lumalabas sa salita ni Kaufman ay sang-ayon sa Rome Statute na nagpapakita na wala talaga pananagutan si Tatay Digong at wala pang ebidensya na representa na to justify yung continuation of trial. So sa tingin ko, naintindihan nyo kung bakit ako naman ay patas sa aking komentaryo. Patas ako sa komentaryo, maski na ako ay naniniwala na inosente si Tatay Digong dahil ang ginagamit kong mga paratang para ma-evaluate kung tama nga ba at mapatuloy sa paglilitis ng kaso ay hindi sarili ko mga opinyon. Dahil kapag sariling opinyon ko yan, tingin ko maraming hindi na makikinig sa akin. Pero ano pong nangyayari? dito sa aking broadcast po ha, sa annotation ko sa kaso, kinakailangan ipatuloy ko dahil hundreds of millions pong nakikinig sa akin. Kung ako po ay parang asong ulol na sumusunod lang kay Tatay Digong nang walang dahilan, hindi po ako susundan ng hundreds of millions na nakikinig sa atin ngayon. Tingin ko nakikinig sila sa akin ngayon dahil alam nila na miski ako may bias na pabor kay Tatay Digong, hindi ko naman papayagan yung bias na pumasok pagdating sa aking diskurso sa mga legal na punto bilang isang abogado, bilang isang profesor ng international law, bilang naging presidente ng Asian Society of International Law. Nakasalalay po yung kredibilidad ko na hindi ako magiging intellectual prostitute kung ang mga pinagsasabi ko dito ay walang basihan. Bukod pa dun sa alam nyo naman na hindi mabuting sa samahan namin ni Hoffman at kung personal na interest ko lang ang aking itataguyod, ookrayin ko si Hoffman. Hindi ko po ginagawa yun dahil ang mga sinasabi naman niya ay mga bagay-bagay na nakasaad sa Rome Statute na mga dahilan kung bakit hindi na dapat magpatuloy ang paglilitis ni Tatay Digong. Pero ang katunayan po, kahit ano pa ang ebidensya, ang international law po, minsan hindi lang yan application of rules, hindi lang yan application of evidence, meron din po yan tinatawag na normative value. Ano ba ang mas mabuti? Ang mundo na narariyan ang ICC o ang mundo na wala riyan ang ICC? Sa tingin ko po, wag dapat dumating sa punto na dapat sagutin niya. Ang importante, dahil meron tayong karapatang pantao na kinikilala, over and above normative values, kinakailangan tignan natin na itaguyod natin ang karapatan ng tao over above all else. So tingnan natin kung malalabag ang karapatan ng Tatay Digong sa presumption of innocence, yung karapatan niya na marinig ang kanyang kaso, yung karapatan niya sa patas sa paglilitis, yung karapatan niya na yung pamamaraan kung paano nakuha ang kanyang pagkatao na dahilan na nagkakaroon ngayon ng paglilitis ay dapat legal, hindi sa pamamagitan ng kidnapping. At alam nyo, kapag hindi sinabi ng ICC na mali ang kidnapping, ganun din ang mangyayari sa kaso ni Maduro na kinidnap din ng mga Amerikano sa Venezuela. At ngayon, wala nang ligtas na kahit sinong mamamayan at dahil ang magiging prinsipyo ngayon, kahit sino ka man, kahit wala kang ginawang paglabag sa batas, kung ikaw ay gustong hulihin, miski kidnapping, pwede ka nang makidnap. Kaya ang aking sinasabi dun sa mga nagsasabi sa international law na dapat bigyan ng mas mahalagang bigat yung mas malawakang interes na itaguyod ang international na katarungan, ang katarungan nagsisimula kung tinataguyod ang karapatang pantao. Hindi po pwede na sasabihin mo na mas mabuti nang nandyan ng ICC dahil yan ang instrumento para magkaroon ng katarungan kung walang mga lokal na hukuman na magbibigay ng hukuman, kung in the first place, yung gawain ng ICC ay dahil sa illegal na pamamaraan. At yan nga po yung pagkikidnap at yung pagpipilit na merong jurisdiction na hukuman. Gayong sang-ayon mismo sa tratado na bumuo sa hukuman ay wala ng jurisdiction ang hukuman na yan. So tignan po natin kung nagtuloy na ang live coverage kasi kanina miski nagtuloy na sila ng live coverage hindi natin nakita, no? So tignan lang po natin. Sandali lang po, titignan natin ICC live streaming. Okay, wala pa po talaga, no? Titignan pa rin po natin kung dito sa isa kung meron ng live streaming, no? Medyo namamalat na ako sa tagal ng aking komentaryo para kung mas mahaba pang sinasabi na mga sinasabi kaysa doon sa mga abogado nagsasalita sa hukuman, no? Yan, tingnan po natin. Okay, wala pa rin po talaga sila. Talagang natagalan sila sa kanilang coffee break. Tignan nga natin ang mga reaksyon ng ating mga viewers. Solid Duterte pa rin hanggang dulo. Dexter Miliana, Rick Abilinosa, mayayari sila dyan. Mapapahiya sila kung mapapalaya. Grabe ang mainstream media tahimik. Si Chef TV 450, Pobreng Pinoy, tapos Brooks Perez, Naka-private session na, bias. Ayan, naka-private session na nga sila dahil nga po redacted yung proceedings, no? Jane Agance, so dapat mga bayaran ang ating mainstream media sa Pinas. Ganda ng paliwanag ni Kaufman. Salamat Attorney Harry Roque, Kalua Hangaway, Young Frax, may magandang nagawa naman ng Tatay Digong, Edwin Moriles, gusot yung present. Ako na, ingat po kayo, lagi watching Singapore, PUM leaders sa mga ungo. Please, paki-full screen naman po ang live. Okay, sige, full screen ko po mamaya. Okay? Full screen ko po mamaya. Tapos sa Solid Duterte pa rin, Brooks Perez, Pipi Kaliwat, ang Sigben, Riz Gestardo, Phil Gamboa, Battleground sa Boto, Haping Tawigo, Tatay Digong, Ace Galatin, ang mga adik noon ay natakot. Rosny Woyet, ang galing mong magpaliwanag po. Salamat po. Evelyn Bernardo, thank you Attorney Harry Roque. Watching from AE, thanks Larubis, thanks Fox. Agatra dyan, okay lang kami. Watching from Saudi Arabia, I support Tatay Digong, Dexter Miliona, bring Tatay Digong Davao, Sheila Marie Manabat. Please explain po sa citation. Masyadong mabilis. Thank you Fox sa live mo, more power. Sa April, thank you Lord, bring him home alive. So yun sa inyo pong pananaw, malakas bagay mensahe. Oh, malakas na malakas po. Pareho po kami ng bago pa po kasi magsalita si Hoffman, sinabi ko na ako anong dapat sabihin ni Hoffman at lahat naman po na sinabi ko ay sinasabi niya. We love you, Tatay Digong. Paano mo mapipresent po ay sila affidavit ng 18 Marines? Well, alam niyo po, medyo sablay ang katugunan ng ICC. Dapat ang sinagot ng ICC dyan, imbestigahan namin itong posibleng misconduct no, ng aming mga investigador dahil ang chief prosecutor nga inimbestigahan dahil siya ay manyakis di umano. No? Edwin Hamora, greetings sa Attorney Harry Roque. Hello Edwin, nawawala na ako ng boses sa kaka-annotate dahil mukhang ang daming redacted dito sa hearing nito. Parang kapag pabor ang sinasabi ng abogado ni Tatay Digong, ayaw nilang marinig ng publiko. Kasi napakatagal na ng redacted dito, no? At nauubos na aking boses sa kaka-annotate, no? Sana sumali ka rito. Papadalang kita ng link, Edwin, at sana ay sumapi ka dito. No? Papadalang ko rin si Mother Dragon, no? Yan. Dali una kay Mother Dragon, yan, pinadala ko na yung link kay Mother Dragon. Tapos, sa'yo, papadala ko rin, Edwin, ha? Teka, titignan ko kung nasa akin ang number mo. Edwin. Naku, wala pala akong number mo. Sa Facebook, papadalang kita ng link, ha? Edwin, para ikaw ay makaakyat dito sa ating discussion, ha? Okay, naku, Edwin, wala ka pala rito sa aking... Wala ka pala, hindi pala tayo friends. So, yan. Yan, Edwin Hamora. Yan, ikaw yan. Okay? Yan, join me. Yan, pinadala na kita ng link ngayon para ikaw makapag-komentaryo rin dahil parang pahaba ng pahaba ang mga ayaw nilang marinig ng taong bayan. So, Edwin, Maharlika, please join in. Ayun na, balik na tayo.
We are in open session, Madam President.
So, Madam President, Your Honours, we're discussing Command Circular number 16 of 2016 and the issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. This directive instructed investigative units on how to perform their responsibilities in the case of armed confrontation during the implementation of Operation Double Barrel. The document also included an exhortation to monitor human rights violations perpetrated by PNP operating units. The term neutralization itself is, of course, not defined anywhere in any of these documents as meaning to kill, a point the prosecution itself conceded at that moment in time when it was seeking the opening of an investigation. And I refer, Your Honours, to ICC 01 on 21, document number 7. So the prosecution, throughout its pre-confirmation brief, invites this chamber to find, by inference, that neutralization means murder, and even carves it in stone as its formal statement of the common plan. But we, the defense, can show that the term neutralization can only mean the use of self-defense where officers' lives are endangered. For this, the text of the circular must be read in the context of the governing framework and other PNP directives. It is our submission that across the political, legislative, judicial, and law enforcement contexts, the consistent articulation has always been that neutralization denotes lawful restraint. At the executive and operational level, the Chief of the Philippine National Police, Ronald de la Rosa Bato, publicly clarified in 2017 that neutralization means arrest. Furthermore, in an official transcript dated 28 October 2024, the former Chief of Police, De La Rosa, testifying for the Committee on Accountability of Public Offices and Investigations, testified that the term neutralization was anchored in the PNP Operational Procedures Manual, where it is specifically and strictly defined. Let us just have a look at what he said. And for your ease of reference, we will also display the said passage in the PNP Operational Procedural Manual to which De La Rosa referred, which incidentally was published in 2021. Neutralization, and I quote, "A police intervention in strict accord with the use of force continuum and/or principle of proportionality on the use of force purposely to contain or stop the unlawful aggression of the offender. This may include an arrest, capture, surrender, or other acts to subdue the suspect." It strikes us as rather mind-boggling that the prosecution should have failed to appreciate the significance of this. It was aware of De La Rosa's speech because they disclosed it to us. But the prosecution's investigators clearly never bothered to read the procedural manual to which De La Rosa was referring. In fact, we know that they didn't because it's not on their list of evidence. Within the judicial sphere, when the terminology was examined before the Supreme Court of the Philippines, in petitions challenging aspects of the anti-drug campaign, the government defended the circulars on the basis that they did not confer a license to kill. The Supreme Court of the Philippines, however, to date, has declined to issue any ruling declaring the campaign unconstitutional, has declined to invalidate circulars, and has declined to rule to date that neutralize or neutralization means to kill. The Supreme Court's treatment of the issue is particularly instructive. The court observed that the wording was it neither
Yun yung
novel
sinasabi ko na paano nila
nor introduced during the
yung
Duterte administration.
Operation Tokhang, Operation Double Barrel. Eh yun na nga.
It had already
Yun na
appeared, for example,
ang papatupad
in
niya.
the
Paano ba
2014
illegal? Sabihin na natin
revised
na yung
PNP manual
ay isang
on anti-illegal drugs
systematic
operations and
pamamaraan.
investigation.
Eh, hindi naman na-deklarang illegal ng Korte Suprema.
In other words,
Ayan ngayon ang pinupruhan
the
niya.
term
So
formed
far naman,
part
kayo naman
of
napanood
existing
mo
police
yung
vocabulary.
pre-hearing annotation na ito yung mga bagay-bagay na dapat
The
sabihin.
court further
Sinabi
clarified
lahat ni
that the mere inclusion of the term in a
lahat ng mga
circular
okay?
does
At
not render that instrument
wala naman sa
unconstitutional,
dokumento nagsasabi na yung
especially
ay dapat
where the circular
Ang
expressly
sinasabi niya,
mandates
sabi tayo,
compliance
sa tao na dapat
with internationally
Para-
accepted legal
hindi
principles,
natin pakinggan.
public policy, and the full observance of human rights, as we showed you earlier. No circular has been invalidated on this basis, nor has it ever been established at the highest level of domestic judiciary that to neutralize means to kill. The judicial record does not sustain such an equation. In each institutional setting, therefore, the term has been situated within ordinary policing powers and constrained by the lawful use of force framework. The testimonies of those operating within that framework, the prosecution's witnesses no less, are aligned with this documentary record. For example, witnesses P1158 and P1170 explained that neutralize means to arrest or to incarcerate through legal means. It did not mean to kill. Witnesses P1050 and P1174 confirmed that lethal force arose only where a suspect's resistance placed an officer's life at risk, reflecting the ordinary doctrine of self-defense and consistent with Mr. Duterte's repeated public declarations that force was justified only in such circumstances. P1214 further indicates that operational decisions were made by officers on the ground within established protocols. So,
Maître, je suis désolée de vous en...
I'm sorry to interrupt, counsel, but once again, you need to be specific and provide the document reference number. You must specify the document number, the reference number for us.
if I may, Madam President,
Merci beaucoup,
of
ma-
course,
Thank you very much.
an understanding with the learned chambers legal officers that we would be able to provide references after the hearing. But of course, the document that I was referring to is PHL OTP 00090518-R01. So, Madam President, Your Honours, taken together, the manual, the public clarifications by police leadership, the state's position before the highest court in the Philippines, and even the prosecution's own corroborative witness testimony, all of this material demonstrates a coherent and consistent understanding that neutralization was articulated as lawful incapacitation through arrest and related measures, not as a policy of killing. And if the prosecution's case for the common plan in counts 2 and 3 is based on Command Circular number 16 of 2016, we might as well pack up and go home because Mr. Duterte is simply not guilty. However, for the sake of completeness, I continue. The fifth indicator of a common criminal plan, as alleged by the prosecution in paragraph 28 of the pre-confirmation brief, appears to be the concerted broadcasting of inflammatory speech. Here, the prosecution once again selectively cites excerpts from 2016 media interviews with Ronald De La Rosa, Bato, and Vitaliano Aguirre, which suit its purpose and case theory, while totally ignoring the more unequivocal comments in those interviews which destroy its case. Regarding the interview with De La Rosa, mentioned in paragraph 28, after supposedly inciting a crowd of drug addicts to cause criminal damage to the properties of their narcotics suppliers, the newly elected chief of police states, "It's either you will die from police gunfire," and he adds, "if you resist." That's PHL OTP 0000849, page 2. Likewise, with the comments in an Al Jazeera interview, PHL OTP 00090340, comments attributed to Aguirre, from which the prosecution imputes criminality to Rodrigo Duterte by citing Aguirre's comment that the administration's policy was to stop crime and kill drug lords. Such throwaway comments reflect on Aguirre alone. And God forbid, we're not alleging that Aguirre did anything wrong. Especially when, in the very same Al Jazeera interview, Aguirre states, not once, but twice, that the policy of Duterte himself was for the police to use lethal force only in self-defense. We can display that on the screen, and the part that I want to read is highlighted. And President Duterte was very clear on this matter, he said, Aguirre, that there will be no killing of unarmed offenders, meaning to say that you use force only when your life is in danger. Later on, in the very same interview, Aguirre would repeat the same theme which exculpates Mr. Duterte, PHL OTP 00090340 at page 4. And I read out the relevant passage which is highlighted once again. They are supposed to arrest them, but when they fight back, then the president has instructed them that they must first protect themselves. So much for Mr. Jeremy's elastic mouth theory. Even he thought that Duterte's speech was bifurcated. And even if he did think so, his so-called perpetrators did not. So why does the prosecution cite the excerpts which support its case so selectively? Well, I'm not going to impute any malfeasance, but I can hazard a wild guess. I would suggest that the people reviewing the prosecution's massive databases for suitable evidence are performing keyword searches. Most likely, some of the most utilized operands were the words kill and perhaps sometimes neutralization or neutralize. Once the member of the prosecutor's staff has his hit, he excises the excerpt, rejoices that he can slot it into the predetermined case theory, and does not bother to read the rest of the item of the evidence, where the exonerating evidence is unequivocal. Turning to the sixth indicator of the supposed criminal plan, as set out in paragraph 29 of the pre-confirmation brief. None of the speeches imputed to the former president, nor the use of what the prosecution calls dehumanizing language, dehumanizing language by the alleged co-perpetrators suggests criminality. I would suggest that it is within the bounds of acceptable, albeit extreme political discourse, to refer to drug users in such a way as beasts, animals, or to the barangays as being plagued by the drug menace. Well, the last one is true. You can hardly expect populist politicians and law enforcement officers to refer to drug pushers and criminals as upstanding pillars of the local community. I really do feel that the prosecution is at a loss if this is its circumstantial evidence for proving the existence of a common criminal plan. The same goes for the seventh supposed indicator of criminality, which is based on the names created for the two police operations, Double Barrel and Tokhang, along with their supposed evocation of firearms metaphors. While the source for this particular gem, witness P1207, a self-confessed murderous villain, might have guns perpetually on his mind and insert their imagery into his daily speech, it does not mean that those who formulated the anti-drugs policy were acting under a similar caprice when they devised the nomenclature for these two particular police operations. And of course, there were other police operations with completely different imagery, such as the one-time, big-time operation referred to by a few prosecution witnesses, and the riding in tandem operation. The mind can only boggle as to what type of nefarious imagery the prosecution believes that that last title evokes. None of the indicators I have mentioned up until now have shown in any way a mutual meeting of minds between alleged co-perpetrators, evincing a communality of purpose or an agreement to act in an illegal fashion. Of course, the prosecution has shown us pictures of the alleged co-perpetrators uttering comments similar to those issuing from Rodrigo Duterte. But this does not indicate a meeting of minds, as I will elaborate shortly. The eighth factor, purportedly evincing a plan of agreed criminality, is set out
Ayan, naputol na naman po, no? Ibig sabihin, redacted na naman. Pero iniisa-isa ni Kaufman kung bakit walang illegal dun sa dokumento na nagsasabi ko ano operation tukhang. Ang pinaka-importanting puntong sinasabi niya, wala namang sinasabi doon sa dokumento na yon na ang high-value targets ay dapat patayin. Ang high-value targets, sang-ayon sa dokumentong yon, ay ang mga tao na dapat sampahan ng kaso at tutukan nga para sa case build-up. At ginamit din niya yung mga paglilinaw, hindi lang ni Presidente Duterte, kundi ni Secretary Vitaguire at saka ni PNP Chief Bato de la Rosa, na dapat yung pagpapatupad na Operation Tukhang ay sang-ayon sa saligang batas, sang-ayon sa karapatang pantao. Walang utos na pumatay ng walang dahilan. Ang paggamit ng dahas ay limitado lamang pagdating sa self-defense dahil meron banta sa buhay ng isang alagad ng batas at ang response na ginamit nila ay proportional. So as far as yung official policy is concerned, yung dokumento na nagsasaad ko ng pulisya ng Operation Double Barrel, malinaw na walang illegal na pagkakautos ang nandoon sa dokumentong yun. At lahat ay ligaw lamang. Now,
Or a solidarity of intent, as would be required for a common criminal plan or a common plan. Concerning and coming to the ninth category of circumstantial proof for a common criminal plan, the prosecution relies on what it believes to be the Duterte's administration's unabashed publication of statistics recording the number of deaths occasioned in the context of the so-called war on drugs. But let us just look at how and where the statistics relied upon were being published. In two government reports, the first of which being the Duterte administration's year-end report for 2017, totaling 63 pages, covering every sector of government and the economy, and of which just 2 pages are devoted to policing activities. We can give you the document ID number shortly. It's on the screen. While the deaths of 3,967 drug personalities mentioned are indeed recorded, as Ms. Robin Croft so helpfully pointed out in her presentation, and are not insubstantial, these deaths comprise a fraction of the 118,287 total arrests for drug-related activities, especially when the government is conducting special operations in a concerted drive to curb the narcotics problem. Such statistics are certainly not indicative of a wholesale policy of murder designed to supplant the process of law. If they were, then certain Latin American state parties would have regularly equaled or exceeded the Philippines in the number of law enforcement killings per capita of the population. What is quite egregious, however, regarding the prosecution's reliance on the 2017 Key Achievement Report is the way in which it glosses over, or rather ignores, those pages which do not suit its case theory. Take, for example, pages 28 of the document, which highlights the fact that 1,900 drug-related investigations had been carried out against law enforcement officers in the preceding year, with 375 police officers being dismissed, including the 2 policemen involved in the murder of Carl Arnaiz, who were later convicted and sentenced to life imprisonment. These policemen were affiliated with the Caloocan city police station, and where, so the report mentions, 1,000 personnel belonging to that station was sent for retraining. To conclude, this document, far from being evidence of a conspiracy hatched between co-perpetrators, is in fact a testament to the Duterte administration's respect for the rule of law and written proof of its intolerance for rotten apple police officers. As for the second official publication, which is supposed to substantiate the criminal plan, we turn to the 2016 annual report issued by the Philippine National Police. The statistics are quoted, with all respect, in a misleading fashion. The tables used by De La Rosa, and particularly the pie chart, show a remarkably low incidence of deaths in comparison to arrests and voluntary surrenders. Obviously, the misleading aspect of that is the prosecution's representation of the statistics, not De La Rosa's. So, coming to the 10th and final source of circumstantial evidence, supposedly supporting the mutually agreed nature of the criminal plan. And this is the fact that the extrajudicial killings, to quote the prosecution's words, followed the same patterns and modus operandi, with the perpetrators covering their tracks. But here, let me ask a question which begs an answer. If the Duterte administration was so barefaced as to openly declare its intent to kill drug users and pushers and celebrate this, as the prosecution argues, in official governmental publications, why would it encourage the perpetrators to go to such lengths to disguise such an intent? I mean, of course, anything's possible, but I'm just pointing out the internal contradiction in the prosecution's case theory. In any event, as they say in English, there is more than one way to skin a cat. And the differing types of modus operandi that we have encountered in the prosecution's 49 incidents of murder involve all conceivable modes of butchery, ranging from strangulation, suffocation, to stabbing and shooting. Now, assuming that the prosecution can overcome the hurdle of proving the existence of a common criminal plan, how has it shown that the so-called co-perpetrators coordinated between themselves to reach a mutual agreement to execute it? Well, it hasn't. All it can do is show a selection of comments made by Mr. Duterte's closest colleagues in government, and all of which take their rhetorical cue from him. The prosecution then artificially defines the intended individuals, the identified individuals, as a collective of co-perpetrators. Now, common law jurisdictions, such as the one I come from, are familiar with these issues in the context of the law of conspiracy. The federal rules in the United States, for example, allow the statements of co-perpetrators to be used as circumstantial evidence, one against the other, to establish the existence of a conspiracy, but require that these statements be made during and in furtherance thereof. Narrative venting, which is what all these supposed co-perpetrators did, the ones identified by the prosecution, does not further the criminal objective. In furtherance thereof means that the statement relied on must advance the objectives of the conspiracy, such as through reassurances, updates, or actions taken to avoid detection. Now, I do realize, Your Honours, that there isn't too much jurisprudence on this matter, but let us look at it logically. Where can one really draw the line if it is sufficient to infer a mutual agreement to execute a criminal plan if we rely only on the statements of the people in the vicinity of a criminally verbose suspect because of the same quality of verbosity it alleges? This is what could be called bootstrapping logic. Building on limited information with the very same information in an attempt to validate that information or to create a structure there without. Put simply, the prosecution has advanced its cart before its horse. It has merely selected a number of individuals working alongside the former president who made similarly offensive comments and has then called them co-perpetrators. Instead of seeking evidence which might shed light on the interactions of these individuals between one and another and construing a criminal conspiracy therefrom, should the evidence even support such a hypothesis, prosecution has taken its preconceived and predetermined premise of a criminal plan and forcibly superimposed it on these individuals. The artifice of the prosecution's working methodology in conjuring up this criminal collusion becomes even more apparent if we examine the evidence emanating from the crime-based perpetrators themselves on a granular level, especially from the prosecution's own star witnesses, 2 of 3 of whom supposedly formed the hardcore of a more limited organization referred to earlier in my submissions. I'm trying to comply with redactions. P1, for example, a self-confessed murderer whose recruitment by the prosecution will be examined elsewhere, was asked about the common criminal plan of his associates up to 2017. And this is what he had to say. Every time somebody was at fault against the government of Rodrigo Duterte, we didn't bother to send them to prison. We would just kill them. That's PHL OTP 0001 2584 at lines 248 to 250. Okay, and that was the audio which I just quoted, and here we have the transcript. PHL OTP 0001 2376 hyphen R02, lines 248 to 250. So, having given you that quote from P1, I would say that as far as this witness was concerned, the common plan was not a refined policy of cleaning up the streets, but rather a killing frenzy of the political opposition. Obviously, no such policy existed, and no such policy is alleged P3, whose evidence relates to the presidential period, describes a similar orgy of killing without rhyme and without reason, but not drug addicts, nor alleged criminals, but rather
Ay, oo, yan, redacted na naman, no? So ito po yung patakaran ng hukuman na may mga bagay na po pwede nilang tanggalin. Nakasama po natin ngayon si Professor Ana Malindugoy. Professor Ana, sana ikaw ay mag-unmute. Hindi kita ma-unmute. So please come in at you are welcome to join our discussion. No? You're welcome to join our discussion anytime. Anyway, ito po ngayon yung tinatalakay ni Hoffman. No? Yung pangalawang argumento niya na yung pamamaraan ng pananagutan na sinasabi nila na co-perpetrator daw si Tatay Digong. So sa madaling salita, ang sinasabi niya, sabihin na nating napatunayan nila na merong ang kasunduan na ipatupad ang Operation Tukhang, Operation Double Barrel, walang illegal dun sa Operation Double Barrel. Ang unang-unang argumento ay ang ating Korte Suprema ay hindi po pinawalang bisa at hindi dineklara na labag sa saligang batas ang Operation Double Barrel. No? Ibig sabihin, hindi po pinatigil ng Korte Suprema ang pagpapatupad ng Operation Double Barrel, hindi po labag sa ating saligang batas at karapatang pantao ang Operation Tukhang. Pangalawa, sablay dun sa sinasabi ng prosecution na ang high-value targets na nababanggit dun sa dokumento na nagsasaad kung anong Operation Tukhang ay wala pong sinasabing ang high-value targets ay kill list. No? Hindi po totoo na yung mga binabanggit na high-value targets ay dapat patayin. Kung hindi, itong mga high-value targets po ay listahan ng tao na dapat maaresto. At syempre, bago maaresto yan, kinakailangan na magkalap ng sapat na ebidensya. No? Nang sa ganun, ang hukuman ay mag-issue ng warrant of arrest. Dahil ang warrant of arrest naman po, hindi i-issue yan sa Pilipinas na walang probable cause. Samantalang sa ICC po, ito pwede mag-issue nga ng warrant of arrest miski wala pang probable cause. At ito nga po ang nangyari sa kaso ni Tatay Digong. Pangatlo, ayan na po si Edwin Hamora. Please, Edwin. Edwin, welcome. Habang nagre-redact ang hukuman doon sa sinasabi ni Kaufman, yung mga bagay na sinasabi ni Kaufman kung bakit hindi illegal ang Operation Tukhang. At ang sinasabi ayan, narinig na kita, Edwin. No? Sinabi ni Kaufman na doon sa Operation Tukhang, na una hindi yan na pinatigil ng Korte Suprema, kinatigan ng sinustain ng Korte Suprema yung pagiging legal ng Operation Tukhang at binasura nga yung kaso na question. No? Hindi ko alam bakit ikaw ay muted pa rin, ina-unmute kita, pero kanina narinig na kita. No? So parang sa end mo, i-unmute mo ang sarili mo. No? Sa end mo ata i-unmute ang sarili mo. Kaya hindi ko may yan, bakit hindi kita ma-unmute. Okay? Ikaw ata mag-unmute sa sarili. Kaya ba? Kaya ba? Hello? Yan, ayan. Okay na. Yan. Please, welcome. You're welcome to join the discussion. Anong appreciation mo so far sa discussion na mga binabanggit ni Attorney Kaufman? Go ahead, Edwin. Yes.
So I hope you can hear me.
Yes, I can hear you wide and loud and clear. Go ahead. So bilang isang ordinaryong mamamayan na hindi bihasa sa batas, naintindihan mo ba ang sinasabi ni Attorney Kaufman at kumbensado ko ba na walang ebidensya para magpatuloy itong paglilitis?
So I heard him. Sandali, dalawang boses ang naririnig ko. By the way, thank you for the invite and good morning by the way sa mga viewers mo. Meron lang akong konting fever and I just wanted to go off kasi I wanted to show the appreciation for inviting me in here. Anyway, narinig ko si Attorney Kaufman sabi niya that the Philippine Supreme Court did not what do you call this? Hindi niya ginawang unconstitutional yung war on drugs ni Digong.
Tama.
Can you explain to us, is it possible for the ICC to say that, hey, you know what, the Supreme Court of the Philippines, you are incorrect for that, tawag nito, tawaging unconstitutional yung
Not
war on
meeting this
drugs?
quota of slaughter.
Malabo yun.
Was
Kasi
randomly
syempre,
grabbing
yung mga
killing
walang hukuman ang may karapatan na
just
magdarako ng
so that
illegal.
there would be something to report on
Kapag
TV
sila ay kukontrahin nila
for
ang
the one-time, big-time operation.
talagang mahirap maintindihan ng ating sabay.
Now, I ask you, how
Hello
can
po.
a country
Hey,
operate
Ana, you're joined also by Edwin.
under a
Hi, Ana.
clear
Alis na ako, attorney, yun lang. I just wanted to say hi to everybody.
Hello po.
criminals for murder?
Yes. Siguro
And thank
patuloy
you
natin
for
That on occasion
balitaktakan pag na-redact uli si Kaufman. Patuloy natin
clean
pakinggan.
arrests.
Mm.
Prosecution's witness, P3. He's not clear when he's actually following their supposed criminal theory or when he's is. What are clean arrests? These are arrests subsequent to which the apprehended criminal would be handed over for a judicial process. And so with that, I believe I have exhausted the first limb of the objective requirement for indirect co-perpetration and have shown conclusively that there was no mutually agreed common criminal plan. Madam President, there are 10 minutes to go. I will start with the concept of essential contribution, which is indeed the second limb that I want to talk about with respect to this mode of liability, which requires the prosecution to show objectively that Mr. Duterte himself made an essential contribution to the furtherance of this scheme of criminality. And what is more, that subjectively, he was aware that he was making such a contribution. This is what us Latin-speaking lawyers, would call the sine qua non test. Or to put it another way, did these 49 murders, which the prosecution has identified, occur specifically because of Rodrigo Duterte's involvement? Or, to make the logic a whole lot simpler, would Rodrigo Duterte's withdrawal from this criminal scheme to target suspected criminals, as alleged by the prosecution, have led to the avoidance of these 78 deaths? Let us see where this test is set out in the Ali Koshaib trial judgment. Paragraph 796. And I'm going to quote the essential part for the purpose of the essential contribution. The accused must make an essential contribution without which the commission of the offense would not be possible. To hold an accused liable as a co-perpetrator under Article 25(3)(a) of the statute, it has to be established inter alia that he or she had control over the crime by virtue of his or her essential contribution to it and the resulting power to frustrate its commission. Well, here, I would like to show you the statistics pertaining to the rate of killings since the former president has left power and the responsibility for law and order has passed into the hands of President Ferdinand Marcos Jr. I rely on a report published by academics at the Third World Studies Center in the University of the Philippines in the context of what is called the Dahas Project. And trust me, The authors of this report, comprising weekly statistics on the first year of the Marcos administration from 2022 to 2023, are no great friends of the former president, Mr. Duterte. This report was even cited, I remember, in a Rappler article, but it's to be found on our list of evidence at PHL D36 0006 0001, pages 006 to 0010. The report for the first year of the Marcos administration showed that out of 342 killings, 160 were at the hands of state agents. And the figures and the statistics just kept on rising. With the second year of the Marcos administration, 2023 to 2024, showing an increase in deaths at the hands of vigilantes, albeit a decrease in deaths at the hands of law enforcement officers, from 46.8% to 34%. Hardly a statistic to be proud of. So with all the prosecutions, fancy bar charts, I'm pretty sure that if they were to recreate them for the period of 2 years after Duterte left power, they wouldn't have room left on their computer screen. The numbers would be so sky high. The conclusion is that there is no reason to believe that Duterte's disappearance from the political scene would have frustrated the ongoing incidents of murder at the hands of state agents or vigilantes. Clearly, I'm forced to ask myself whether anyone on the other side of this room has thought of investigating the Marcos regime and the related phenomenon and holding someone accountable. Why are my colleagues sitting to their right, the victims' representatives, not clamoring for accountability for those deaths? Or is it of no consequence now that Mr. Duterte is sitting in the ICC detention center? I've reached a natural break, Madam President, in my submission. With your permission, I would like to continue after lunch.
Judge Motok. Thank you very much, Mr. Kaufman. We will suspend the hearing now
Suspendido na po ang
for
hearing
90
kasi
minutes to
manananghalina.
resume at
Pero
2 p.m. Thank
by
you
way
very
of
much.
recap ay ang unang in-address ni Kaufman ay yung kawalan ng elemento ng mens rea na tinarget ang mga biktima ng patayan di umano dahil sila ay mga inosenteng sibilyan. Yung sinasabi ni kasamang Maharlika na ginurgur dahil sila ay mga inosenteng sibilyan. At ang sinabi ni Kaufman na sinabi rin natin sa simula ng ating broadcast, kinakailangan patunayan nila na alam ni Tatay Digong bilang akusado na ang tinatarget ay mga inosenteng sibilyan at ang dahilan na sila ay tinatarget ay sila ay mga sibilyan. Wala pong ganyang ebidensya. Dahil lumalabas po ang mga naging biktima ng patayan ay mga tao na di umano ay may kinalaman sa pangangalakal nga ng droga o di naman kaya ay talagang nanlaban. So, basta mapakita na hindi talaga tinarget ang mga biktima dahil sila ay sibilyan o kung hindi dahil sa mga ibang pamamaraan, yan po ay magiging dahilan para mawala yung pinaka-importanting elemento ng crime against humanity na targeting of civilian populations. Pangalawa po, matapos niyang ma-dispute yung kawalan nga ng mens rea, yung pinaka-importanting mental intention na tinatarget ang mga inosenteng sibilyan dahil sila ay inosenteng sibilyan, ay pinasinungalingan naman niya yung tinatawag na co-perpetrator. At dalawa yung bagay na pinupruebahan niya, nandun na siya sa pangalawang punto. Yung unang bagay ay walang illegal na sabwatan para pumatay dahil yung operation of land na tukang ay legal nga at ito nga ay sinang-ayunan pa ng ating Korte Suprema at hindi dineklarang ang unconstitutional. At pangalawa, walang walang ebidensya na nagpapakita na ang patayan ay dahil sa pag-utos ni Tatay Digong at ang ginamit niya ay yung mga data galing sa Third World Center ng University of the Philippines na nagpapakita na mas maraming biktima ng patayan ngayon sa panahon ni Marcos Jr. At ang tanong nga niya, bakit kaya hindi nagrereklamo mga abogado ng biktima dito sa mga namamatay? At kinungklud nga niya, bagaman ng halian, ang tanong ay bakit dahil ba ito ay si Tatay Digong ngayon ay nakakulong na. So kasama po natin si Professor Ana Malindugoy. Professor Ana Malindugoy, napaka-importante na yung mga obserbasyon dahil ito ay hindi lang naman legal na proseso, ito po ay isang political na proseso rin. Kaya kung sana ikaw ay makapasok na dahil sinasabi niya hindi daw okay ang kanyang StreamYard, no? Sayang naman. Pero kung kaya mong pumasok, ayan, the floor is yours.
Oo, natag dito, naririnig ako.
Yes,
Oo.
naririnig Professor Ana. Anong
Okay. Sa akin naman, parang maganda naman ang presentation ng defense ni Attorney Kaufman at napo-point out naman niya yung mga kailangan na i-debunk na present ng prosecution ng the last 2 days na the first and the second day kasi nagkaroon ng break kahapon. So I think happy ako to a certain extent. At saka ang maganda lang doon na talaga na tumatak sa akin sa presentation ni Attorney Kaufman is first and foremost yung issue na ang word na to neutralize or neutralize is not necessarily or does not necessarily mean na to kill, which is actually from a Filipino perspective, given the context that we have and given na nasubaybayan naman natin ang buong presidency ni Pangulong Duterte at tayo na may mga Pilipino nasa bansa natin, alam naman natin sa konteksto ng kanyang mga speeches na when you talk about na the word neutralize na na-emphasize ni Kaufman is actually, ang naririnig ko pa nga kay Pangulong Duterte noon is to subdue. And subdue doesn't necessarily mean to kill. So yun yung isa sa mga nagustuhan ko dun sa defense ni Attorney Kaufman na I think is a very good is a strong defense kasi kung titignan mo sa prosecution nung first and second day, in-emphasize nila yung tinatawag mong neutralization or to neutralize na ang kanilang sinasabi is to kill na, which is actually doon din ako nag-iisip na bakit ganun ang kanilang definition. Ang another point that I really like also in the defense ni yung presentation ng defense team ni Pangulong Duterte is yung paglalahad na ang Supreme Court sa highest judicial court natin, which is the Supreme Court, na ipahayag na yung mga policies ng yung operations, yung policy, national policy in combating drugs or during the drug war, in-uphold naman yan at hindi nagkaroon ng contradiction or hindi ni-rule ng Supreme Court na it's unconstitutional. So that is a very good, I think that was also one of the strongest point na sinabi ng defense. At saka yung sinasabi nga niya, hindi ma-establish yung direct connection. Kasi sa Article 7 of the Rome Statutes, the most important is kumbaga kung may systematic na